Hello.
Hey, Tim.
Hi, Sean. Hi. I just wanted to let people know that I'm on the call. I'm just having some issues with Zoom on my computer right now, but I'm on the phone, so just wanted to
Okay,
let folks know.
thank you.
Yep.
And we're just going to give folks another minute to join, and then we'll go ahead and get started.
Great.
All right, let's go ahead and get started. And as folks join, we can, we can keep going. So thank you all for being here today, and welcome to the Fenway Trans Health Programs Q&A on the recent HHS ruling and the Supreme Court decision on employment discrimination. My name is Noah. I use they, them pronouns. I'm the patient advocate of the Trans Health Program, and I'm joined by our panelists today, Sean Cahill, Tim Wang, and Chris Erchull for this event. And I'm going to have our panelists each introduce themselves, but I also just want to briefly go over the format for this event. So we're going to start out with a brief overview of the HHS ruling and the Supreme Court decision so that we can all kind of have a general starting point. And then we can go ahead and jump into people's questions. You can either feel free to submit questions in the chat or use the raise hand feature, and we can get to your question that way. And I will read the questions out loud. And also just to remind folks that this is a recorded event. And so you can turn off your camera unless you're speaking. And also just a reminder to leave your mic muted unless you're asking a question or speaking. And then we also had some questions that were sent to us ahead of time that we can ask, but we'd also love to hear from folks if you have any questions. So yeah, you can feel free to submit questions at any point during this event. And then also, we will be posting the recorded event on our website, as well as any resources that we talk about today. So you can feel free to access that at any point. So yeah, let's go ahead and have each of you introduce yourselves, your name, your pronouns if you'd like, your organization, and tell us a little bit about the work you do. And then we can move ahead and start with the overview of each of the rulings. Chris, do you want to start?
Sure. Hi, my name is Chris Erchull. I use he, him pronouns. I am an attorney with GLBTQ Legal Advocates and Defenders, better known as GLAD. We're based in Boston. We are New England's leading legal advocacy organization for the LGBTQ community and for those living with HIV. I'm really happy to be here today. Thank you.
Sean, go ahead.
Hi, everybody. I'm Sean Cahill. I'm the Director of Health Policy Research at the Fenway Institute at Fenway Health. The Fenway Institute is the research, education, and training and policy arm of Fenway Health Center. And I also have academic appointments at Northeastern and Boston University. And I'm a member of the Massachusetts Transgender Health Coalition.
Thank you, Sean. Tim?
Hi, everyone. My name is Tim Wang. I use he, him pronouns. I'm a senior policy analyst at the Fenway Institute in the Health Policy Research Department. And I work very closely with Sean, and I'm happy to be here today.
Yeah,
No, we can't hear you for some reason.
You can't hear me at all?
Now we can.
Oh, okay. So thank you all for joining us, and I'm really happy that you're all here. So yeah, if one of you wants to kind of start out talking about the kind of an overview of the HHS ruling, and then we'll go over a brief overview of the Supreme Court decision as well.
Chris, do you want me to talk about the HHS ruling and then you talk about the court ruling? Is that good?
Yeah.
So, so on Friday, June 12th, and by the way, I use he, him pronouns. I'm sorry, I forgot to mention that. On Friday, June 12th at 4:30 in the afternoon, the Trump administration finalized the repeal of a number of non-discrimination provisions in federal regulation. The one that gets the most attention is a rule implementing Section 1557 of the Affordable Care Act, which was put in place by the Obama administration, and it explicitly prohibited gender identity discrimination in healthcare. It also explicitly mentioned non-binary people and intersex people, as well as transgender people. And in addition to prohibiting gender identity discrimination, it provided some protections for lesbian, gay, bisexual people against discrimination based on sexual orientation that took the form of sex stereotyping. So for example, if a lesbian couple sought assistance with fertility and was told, well, I'm not going to treat you because I think every child needs a mother and a father, or I think that two women should not have children, that could be seen as sex stereotyping and be prohibited by the Section 1557 rule. The Trump administration repealed that rule and removed gender identity from the guidance, from the regulation. In addition to that, they pulled explicit sexual orientation and gender identity non-discrimination language from 10 other sections of federal regulation in 7 other regulations. So those were regulations that governed healthcare services, insurance coverage, both private insurance and public insurance, Medicaid. It covered the state and federal health insurance exchanges that were set up under the Affordable Care Act to provide subsidized insurance for people where they pay out of pocket, but there's some kind of government subsidy to help them afford it. And then there were 3 Medicaid provisions governing enrollment, access to services, and cultural competency training that mentioned sexual orientation, gender identity. And then finally, there was a regulation governing the PACE program, the Program of All-Inclusive Care for the Elderly, which is a combination of healthcare and elder services for nursing home eligible older adults. And many of those are frail elders and low income elders. And so SOGI language was taken out of 7 regulations, gender identity explicit language out of the 1557 one, but overall 11 mentions of gender identity and 10 mentions of sexual orientation were ripped out of federal regulation that provided protection for LGBT people in healthcare.
Yeah, so I'm going to go ahead and talk a little bit about the Supreme Court decision, which was issued the Monday morning following the Friday afternoon federal regulation drop. So June 12th, 4:30 p.m. on the anniversary of the Pulse nightclub massacre, the Trump administration releases these terrible rules. And then right at the end of the weekend on Monday morning, we're blessed with this wonderful Supreme Court opinion that totally undermines what the Department of Health and Human Services had just issued the previous Friday. And so just to be clear, the decision which is called Bostock versus Clayton County, actually encapsulates 3 different Supreme Court cases into one decision. And the 3 different court cases were all employment discrimination cases where people had been fired because of their sexual orientation or gender identity. So 2 of the cases involved gay men who were fired from their jobs for being gay men, and the third case involved a transgender woman who was fired from her job for coming out as transgender. And what the Supreme Court said in that ruling was that the prohibition against sex discrimination in the workplace, which is Title VII, which is found in Title VII of the Civil Rights Act, that prohibition against sex discrimination also, by definition, applies to discrimination against people because of their sexual orientation and because of their gender identity, or because they are transgender. And so any employment discrimination that takes place on the basis of sexual orientation or gender identity, basically any employment discrimination against someone because they're LGBTQ, that's now actionable as a rule across the country. And what this ruling does is it's pretty transformative in a lot of ways, but there are about 30 states in the United States that had no protections on the books in their state laws against employment discrimination based on LGBTQ status. And so suddenly, just as of Monday morning, all of those state laws that protected only against sex discrimination now also have the Supreme Court's definitional explanation that also encompasses LGBTQ discrimination. So that's a huge deal right there. I will say that, like, in many of those states, we had still been operating under the belief that sex discrimination does include sexual orientation and gender identity discrimination. So there were already lots of actions that were being taken on that front, and people were able to win their lawsuits up until this point. But what the Supreme Court decision does is it resolves any confusion or any ambiguity or any different outcomes. Everybody is on the same page now that sex discrimination includes sexual orientation and gender identity. And it goes further because, I mean, we already know that here in Massachusetts, we've had protections for a long time for employment discrimination on the basis of sexual orientation and gender identity as just part of state law. But the state law doesn't always apply and isn't always the best way to advocate for the discrimination you face. So by having federal law definitionally protect LGBTQ people in employment, there's no longer that issue of, like, sometimes state law doesn't do it enough, even in a state like Massachusetts. And in fact, actually, one of the cases that the Supreme Court was deciding was an employment discrimination case from New York State. So the plaintiff was a gay man who was fired in New York State, and he was unable to rely on New York State law because of the specifics of his particular claim. And so, you know, discrimination laws are only as good as they can be enforced, you know. So in that example from New York State, it was really imperative that federal law give him protections. And I'll talk more a little bit later about a federal lawsuit that I'm litigating right now on behalf of a Massachusetts man that has an employment discrimination component where state law protections didn't apply. So, but then going beyond just employment discrimination, there are federal laws that protect against sex discrimination in a bunch of different ways. There's Title VII, which is the employment discrimination component, but then there's Title VIII, which is the Fair Housing Act, and that prohibits discrimination on the basis of sex. And then there's Title IX, which is the education discrimination law that protects against discrimination on the basis of sex. And then there's another statute that protects against credit and lending discrimination on the basis of sex. And then finally, the Affordable Care Act, Section 1557, explicitly protects against discrimination on the basis of sex. So now all these federal laws that protect against sex discrimination, by definition, according to the Supreme Court of the United States, that encompasses sexual orientation discrimination and transgender status discrimination or gender identity discrimination. So across the board, anytime you see sex discrimination in a federal law, it's going to apply to protect LGBTQ people as well. And so that's the short answer of what the Supreme Court decision does. If we have time, I'd like to just say another couple of words about what the Supreme Court decision said. Okay, so the Supreme Court decision said basically, or essentially, that it's actually pretty obvious that if you're discriminating against someone because they're gay, or because they're bisexual, or because they're non-binary, or because they're transgender, you're automatically thinking about and making a decision about them based on their sex, okay? You are saying, what do I think of this person's sex? How do I perceive this person's sex? How do I perceive it in relation to other people? and it's a pretty obvious answer. If you're thinking about someone's sexual orientation or you're thinking about someone's gender identity, you're definitely thinking about their sex. And there's so many ways to frame it. You could say, if, you know, Bob and Julie are both married to someone named Barbara, but you're firing Julie for being married to Barbara, and you're not firing Bob for being married to Barbara, then you're firing Julie because of her sex. That's the difference between Bob and Julie. Julie's a woman and Bob's a man. That's a very obvious way to think about it, but there's just so many other ways to think about it. If you're firing Amy Stevens, who is the transgender woman who came out at the workplace because she's refusing to wear a man's uniform, you're firing her because you're thinking about her sex in relation to her job performance. It's just very obvious. And what Justice Gorsuch said in his opinion was that it was an elephant in the room. It was something that was so obvious and unavoidable that even though it's taken decades for the Supreme Court to come to this realization and say it, it's an obvious answer. And so a lot of people are surprised about the outcome of the Supreme Court and see it as a surprise because, oh, there are conservative judges who've been appointed. But I just want to make the point that you know, as surprising as it might be, like, you know, from a media perspective, it's not surprising because it's like the most obvious answer in the world. You know, of course it's sex discrimination when you fire for someone because they're LGBTQ. And so that's essentially what the Supreme Court decision said, and we can move on.
Now we can't hear you again.
Oh, you can't hear me? I wonder.
Yeah, now we can.
Okay. I wonder if I just need to speak up because of my microphone. But anyways, I really appreciate you both giving those overviews. I don't know if Tim, if you wanted to add anything, or if I can just start jumping into some questions. Yeah, Tim, feel free to jump in, or I'll go ahead.
No, go ahead.
Okay, sounds good. So you both talked a little bit about the implications of the HHS ruling and the Supreme Court decision. I'm wondering if you could talk about the implications kind of on, you know, on a day-to-day basis. How does this ruling, how does the 1557 ruling impact trans and gender diverse communities? And then Chris, I don't know if you want to expand on how the Supreme Court decision impacts 1557 as well.
Yeah, so I'll respond to sort of the impact of the rules, the change in the rules, and Tim, feel free to jump in as well. So we have a lot of research that shows that transgender people and LGBT people experience discrimination in healthcare, and so the Fenway Institute has been doing work now for about a decade, training health centers in particular, but also hospitals and private practices and health professional organizations to try to help them do a better job of providing care to LGBT people. And since this is focused primarily on transgender people, I'll focus on transgender people in particular, including gender non-binary people. And so we train providers in how to provide affirming care, how to use the right pronouns, how to use the right name that somebody uses, but also how to be clinically competent and to know what kind of preventive screenings to offer a patient and things like that. But the federal government, this administration, I mean, the broader context is that this administration has taken more anti-LGBT actions than any previous presidential administration. And so it has been challenging, you know, the right of transgender people to serve in the military. It's been rolling back protections for transgender students through the Department of Education. And it's also actually going back to the 2016 Republican Party platform. That party platform talked about how the Republican Party opposed the interpretation of sex discrimination to encompass gender identity discrimination and sexual orientation discrimination. One of the quotes from the Supreme Court ruling that I found really compelling was, it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. So that's what Chris was just talking about. But it's very, very strong. And the Republican Party and President Trump has had just the opposite view, that anti-LGBT discrimination is not a form of sex discrimination. And so, so the Justice Department under President Trump has really challenged that interpretation of sex discrimination to encompass anti-LGBT discrimination, which has been circulating in the lower federal courts for the last 20 years and in the Equal Employment Opportunity Commission. And it's just finally been endorsed by, in a very strong way, the Supreme Court. I guess the final point I make is that, so we're doing all this training in the healthcare settings, and one of the things that we do is we encourage healthcare institutions to adopt non-discrimination policies, to train their staff, especially those that are in states like Mississippi, where there was not a legal protection for people until just a couple of weeks ago with this court ruling. And I think that by the Trump administration on June 12th saying LGBT people don't deserve protections, don't have protections in healthcare, that sends the message that it's okay to discriminate against LGBT people in healthcare. And the trainings that we do, there's always somebody on staff who doesn't support it, who says things like, well, we should treat everybody the same. And why are you singling out LGBT people for special treatment? Which is, of course, not what we're doing. But there's always somebody who objects to the cultural competency training that we're doing. And I think that the step that the administration took 2 weeks ago is emboldening those people to speak out, to resist, to drag their feet, to try to muck up the works and prevent the health center from, taking steps to provide more affirming care. So Tim, do you want to add anything, or and if not, we'll go to Chris to talk about the Supreme Court case.
Sure. I think I would just add to that, just to underscore what you were saying, Sean, about the importance of training and having organizational non-discrimination policies that are really strong in this case. And I think that it is good in this case, just to underscore the fact that Massachusetts does have good state laws around this. And then just to provide a further update on some actions that folks are taking about the Section 1557 rule at the national level, our colleagues at Whitman Walker, which is an LGBTQ health center in DC, as well as a couple of other LGBTQ organizations across the country, are working with ACLU to file a lawsuit against the federal government over Section 1557. And I think that the Supreme Court ruling really is going to be really helpful for them in that case. So I think that there is action going on right now to push back against it at the federal level, but I also think that in terms of Massachusetts, we do have all this training going on that we're a part of, and we also have good state laws in place. So I think that's just something that I wanted to underscore.
Yeah, so I'll just add that what the Supreme Court, just to make it absolutely clear, what the Supreme Court decision does in relation to the Health and Human Services new final rule, they're in direct tension, and they contradict each other. You have the Department of Health and Human Services saying it's not sex discrimination to discriminate against someone because they're LGBTQ. And then on the other end, you have the Supreme Court saying it is sex discrimination. And so when you have a contradiction like that, one of those things has to be wrong. And the Supreme Court ruling is the supreme interpretation of Section 1557 of the Affordable Care Act. So therefore, the Health and Human Services rule is wrong in its interpretation of sex discrimination, and it's not going to hold up in court. And so just to build off of what Tim was just talking about, there are two organizations that there are two lawsuits that have been filed. One of them by Lambda Legal on behalf of Whitman Walker and a bunch of other organizations. And so that lawsuit, and then that lawsuit's based in the federal court in Washington, D.C. And then the other lawsuit that was filed just the other day was filed by the Human Rights Campaign on behalf of 2 transgender women in the Eastern District of New York in federal court. And both of them kind of do the same thing, which is attack the regulation for being like procedurally incorrect, which means that the way they went about writing this rule is incorrect because they didn't follow all the rules they were supposed to follow before coming up with the rule, like the one that they did. And then the second part of what each of these lawsuits is claiming is that it's unconstitutional what they did. Now, in a practical sense, the HHS rule is already unenforceable. There's nothing that, like, there's no court that would be able to enforce it now that the Supreme Court has said that the opposite is true. So if somebody files a lawsuit saying that you discriminated against me because of my sex in healthcare, if a transgender person or an LGBTQ person files a lawsuit and says like that's sex discrimination, they're going to win, at least on that point of it being sex discrimination, regardless of what the Health and Human Services rule says. So back to Sean's point though, what it really does is it emboldens the people who would discriminate against us, and it creates a whole lot of confusion among healthcare providers, among employers, among insurance companies, who have all been kind of led back and forth along a path where they have biases and they have their own prejudices and they have their own assumptions about what they should be and should not be able to get away with in terms of covering people or denying people access to care. Yet they're getting conflicting messages from major governmental sources, and that's just going to create so much confusion. And in reality, you have a person who's going to seek healthcare and is going to be denied healthcare, denied access to the hospital, or be discriminated against in healthcare, and think, I don't know if I have any remedies because of all this like misinformation and contradictory information that's coming out all over the place. So it's really, really important that we work together to send a good, clear public message that any discrimination in healthcare access, any discrimination against LGBTQ people is sex discrimination, and it's actionable under 1557 of the Affordable Care Act.
Mm-hmm.
Thanks for the clarification. And just a reminder, feel free to submit questions in the chat or use the raise hand feature, and we can hear questions that way as well. But I will move on to the next question. Could you tell us a little bit about the history of 1557 and how we arrived where we are today? And how about the history of the cases brought to the Supreme Court? I know you talked about, the three, it's the 3 cases, but I don't know if you could also expand on just the history of that as well.
Sure. So I'll start off with the 1557 rule. So it was issued by the Obama administration in 2016. I think it was, I'm not sure exactly which month. It was around the middle of 2016, but it was the result of a lot of input from LGBT health advocates for many years before that, because we knew that discrimination in public accommodations was an issue, and healthcare is a public accommodation. We knew that discrimination constituted a barrier to LGBTQ people accessing healthcare. So like we did a study here in Massachusetts. We surveyed 452 transgender and gender non-binary people living in Massachusetts about 6 years ago now. And we asked them if they had experienced discrimination in healthcare in public accommodations. And about 25% said that they experienced that kind of discrimination in healthcare. And altogether about 2/3 experienced it in some kind of public accommodation. Those who experienced discrimination in a healthcare setting were less likely to seek care subsequent to that experience, both routine preventive care and emergency care. And we also found that those who reported experiencing discrimination in a public accommodation, so that included things like the subway, the bus, the commuter rail, stores, restaurants, public spaces. Those who experienced discrimination were about twice as likely to have negative physical and emotional symptoms. And that included things like headache, pounding heart, upset stomach, feeling frustrated, feeling sad, feeling depressed, feeling angry. So the point there is that experiencing discrimination has negative effects on your health, both your mental health and your physical health, but it also is a barrier to accessing care. So for all of those reasons, we advocated with the Obama administration, with Secretary of Health, Kathleen Sebelius, and then subsequent secretaries, to try to get language written in that was explicit about both gender identity and sexual orientation. And what we ultimately got was very robust language related to gender identity, and it was somewhat less robust than we wanted to see in terms of sexual orientation. But then they wrote a bunch of other regulations that got less attention, that governed qualified health plans and other elements of the private insurance market, Medicaid, and elder services. So those were very important. So that's where they came from. The Obama administration was a real partner to the LGBT community, and they worked closely with us and did a lot of good things, and this is one of them. This administration is very different.
And just to add to that a little bit, once those regulations went into place, an organization brought a lawsuit in Texas to try to, similar to what we're seeing now, to try to invalidate those regulations when they were put into place back in 2016. So those Obama era regulations were subject to a lawsuit, and right away the judge ruled that those regulations were invalid. And just one judge in Texas had the power to do this and influence the whole effect of those rules actually taking effect and actually having any influence on policy throughout the country. And so as soon as mid 2016 the rule went into effect, the end of 2016 it was put on hold by this injunction issued by a Texas federal court judge. And so then it wasn't until so when the Trump administration started, the rule was already put on hold by that Texas judge. They didn't need to do anything. To keep it from going into effect, and then they took their time issuing this new discriminatory rule. But we've known it's been coming this whole time, and they relied heavily when they issued the new rule. They explained this lawsuit in Texas, it says everything we need to know about how it's not sex discrimination to discriminate against LGBTQ people, and so the Supreme Court decision, the Bostock versus Clayton County recent Supreme Court decision really invalidates that Texas court decision that put the whole Obama era rules on hold. So that's really interesting too, that that one judge managed to issue a ruling that put the rules on hold after the Obama administration had worked for years to come up with this, way to implement the protections of Section 1557, and then like that they were suspended.
It's interesting for me as someone who doesn't have a background, like a legal background or a policy background, to hear about the ways in which this Supreme Court ruling really does impact the 1557 ruling. It's really helpful to get that clarity. And then kind of in line with some of the stuff that you mentioned, Sean, could you talk a little bit about the healthcare and employment protections that currently exist for trans and gender diverse people in the Commonwealth of Massachusetts? And how about protections outside of the Commonwealth?
Sure. So we have a statewide non-discrimination law that includes gender identity, and it includes it in relation to employment, housing, public accommodations, and credit. So we're one of, I think, 21 states that have those laws. And then there's 2 additional states that have I think Michigan and Pennsylvania that have interpreted their sex non-discrimination laws to encompass anti-transgender discrimination. So that's 23. And then there are a number of states, including southern states like Alabama, where there's a federal court precedent that interprets sex discrimination to include anti-LGBT discrimination. So now with the Supreme Court case, it's really the whole country where transgender people are protected against discrimination in employment, clearly based on the Supreme Court ruling. But as Chris said, I think more broadly in terms of housing and public accommodations as well. But certainly here in New England, all 6 New England states have gender identity non-discrimination in all the major aspects of social interaction. And we are protected. We have a very strong Attorney General who has been aggressively, enforcing those laws, who's a real staunch advocate for the transgender community. So I hope that's helpful. And Chris and Tim, feel free to add to that.
Just one point of clarification. There's not a federal law that prohibits sex discrimination in the context of public accommodations. There's no such federal law right now. There is for disability discrimination and there is for race discrimination. And even the race discrimination one doesn't cover very much. It covers just a small subset of public accommodations. But there's no broad federal law that prohibits sex discrimination. So individual states can still make the claim that even if they have their own state law prohibiting sex discrimination in public accommodations, they'll still be able to make their own case within that state that, like, okay, maybe in federal law, sex discrimination includes LGBTQ discrimination, but not here in our state. And then there would have to be some sort of challenge to that. Is that interpretation of state law unconstitutional under the federal constitution? So we don't know how that would pan out yet at this point.
Yeah, that's one of the interesting things about the Civil Rights Act that I think a lot of people don't know, and I didn't realize it until a few months ago, that the prohibitions against sex discrimination and religious discrimination only apply to employment. They don't apply to housing and public accommodations. So, many states prohibit discrimination in those areas, but not all. And Chris also mentioned kind of the conflicting messages coming out from the federal government, where you have the court saying anti-LGBT discrimination is sex discrimination, and the Trump administration saying it's not. You also have the Trump administration promoting what we call religious refusal policies, basically policies where they embolden a healthcare provider or social service provider to refuse to provide care to somebody based on a religious or moral belief. We're very concerned about what that can mean for transgender healthcare, for social services. The administration has been very aggressively implementing these policies throughout the Health and Human Services system. There's now about $500 billion a year worth of services funded by Federal Health and Human Services Department, which involve anti-poverty programs, homeless services, refugee resettlement, healthcare, elder services, youth services, and they're encouraging. They're basically saying to people, you don't have to provide services if it violates your religious or moral beliefs. So, that, in our view, poses a great threat to LGBT people's ability to access services. We know that in our community, particularly among people of color in our community and transgender and bisexual people, that we have higher rates of poverty. So we're probably in need of some of these anti-poverty programs more than the general population. We know that LGBT elders are more in need of formal caregiving assistance because we're less likely to have kids and grandkids to provide that care. So that's another area of great concern. And even though this court ruling is very good, and eventually I think it'll have broader implications than just deployment, it's going to take a long time and a lot of court cases to get to that point. Meanwhile, people could experience discrimination in trying to access healthcare and social services.
Yeah, and there was a comment while you were talking, Sean, about the you know, the healthcare providers being able to discriminate because of their religious beliefs, that this does go against the oaths that medical providers take about, well, I'm actually not a medical provider, so I won't. But yeah, it does go against the oaths that they take. I did kind of want to jump ahead and ask one of the questions that we received ahead of time, because you talked about people facing discrimination. And so we were wondering, what can someone do if it seems like they are being discriminated against, either in a healthcare environment or an employment environment? And what resources are available to someone who might be experiencing discrimination in either of those areas?
I would go to you, Craig, for that.
I would say that the answer that I always give to this question is reach out to GLAD Answers. That's our hotline. You can call us on the phone, although right now we don't have volunteers to operate the hotline, so you have to leave a voicemail and we get back to you. And you can also contact us online. So our phone number for GLAD Answers is 800-455-GLAD. And you can also contact us by email at, well, there's actually a form on our website on the glad.org website that can put you right directly through, and you can fill out the information about your specific issue that you're experiencing, and you'll always get a response from GLAD Answers, whatever you're experiencing discrimination. And if you're in New England, where we are helpful in terms of helping you navigate the different kind of discrimination claims systems that exist in different states. And if we can't provide you direct legal support, we can hook you up with a lawyer who can provide that kind of support. So if you're experiencing discrimination or you know someone who is, please, please, please contact GLAD Answers, either calling 800-455-GLAD or going to glad.org and glad.org and filling out an online request for help, because we have this amazing service and we want to make sure that everybody knows about it and can use it for when they need help and face discrimination. But also just some general advice: record everything. Write down, after you've had an experience where you feel like you've experienced discrimination, write down everything right away. Always try to bring someone with you if you feel like your doctor says something to you that doesn't sit right. The next time you go see that doctor, try to bring someone with you so that you can get a third party's point of view, but then also have that extra resource of someone who is there who can say, like, yeah, that didn't feel right what was happening in that circumstance, and I saw it the same way. So just always try to get and collect and keep as much information as you can, and always ask for help.
Chris, and I will put those resources when we post the video, so that'll also be available through here.
Thank you.
Let's see. One of the questions that we received ahead of time was, if someone has a self-funded insurance plan, can their insurance plan change in the middle of the plan year to start discriminating against trans people?
I can take a stab at answering that question, and Sean, jump in if you have more information or knowledge than what I offer. But my understanding is that it would be a really complicated thing for a self-funded plan. So a self-funded plan, for those who don't know, isn't like a typical insurance plan. It's something where an employer, it's usually through an employer, they pay the total premium, the total amount for all the healthcare for all the people that are on the plan every month, instead of like an insurance company where the insurance company pays the total amount of the healthcare, and then the employer just pays a premium, which is the preset amount that they decided ahead of time. So the risk falls with an insurance company in traditional insurance, but the risk falls with the employer in a self-funded plan. And because of the complicated systems that you have to navigate if you're setting up a self-funded plan, to shift mid-year would put you at so much risk that you wouldn't do that. So in reality, whether or not someone might choose to actually do that, I don't think any self-funded plans are going to be doing that because of the big risks that they'd be undertaking to do it. I don't think it's like something we need to worry about, is that there would be a sudden change where suddenly a plan excludes things that weren't excluded before. But it's really important to read the details of your self-funded health benefits plan and read the plan to see what is excluded and what's not, because they might say that something's excluded, but you might not know it because you've been getting your claims processed for your HRT or whatever. And then when you go to get top surgery, suddenly they're saying like, oh, we exclude all transition related care. And you might be like, what the heck? I've been covered all this time for my HRT. How could I suddenly not be covered for top surgery? And the answer is that that there's all sorts of ways that could happen. Like it's a very complicated thing. But one more point about self-funded plans: you don't know if you're under a self-funded plan a lot of the time because your claims are processed the same way as like a normal insurance company, because they hire an insurance company to do all the processing and sending you a card and everything else. So like from the point of view of the person who's receiving the benefits, it looks basically the same if you're in a self-funded plan or an insurance plan. So it's really important to like pay attention to that when you're starting a new job or getting on a new plan, to know if it's a traditional insurance plan or if it's a self-funded plan. And the major difference between the two isn't like, the laws are the same basically as they apply to everything, but they're not, because what happens is they're regulated in different ways. There's a whole insurance commission in Massachusetts and in every other state that like regulates individual insurance plans, and they keep an eye on things and make sure that these discriminatory plans aren't going out there. But an employer who's setting up their own self-funded plan, there's no oversight body who's looking at the individual plans to make sure that they comply with discrimination laws. Sean or Tim, do you have anything to add to all that?
Yeah, I would just add, you mentioned the Division of Insurance. The Massachusetts Division of Insurance regulates private insurance plans, and every state has a similar body with some kind of similar name. And then, our public insurance policy is called Mass Health here in Massachusetts. It's run by the Department of Medicaid, or the Department of Mass Health, which is what our state Medicaid is called. In response to the Trump administration's pulling back of all these non-discrimination regulations that were explicitly included sexual orientation and gender identity, Mass Health put out a statement saying that it would continue to cover transgender health care as it did before. It would continue to be there for transgender patients, which is great. And they took this in a very proactive way. The Division of Insurance, we in the Massachusetts Transgender Health Coalition, we have been engaging the DOI and trying to get them to put out some kind of a statement, and hopefully they'll do that sometime soon. There was because the discriminatory actions of the Trump administration were, they had put out a preliminary rule a year ago, and we knew it was coming. Other states actually put out a very strong statement. About close to 20 other state divisions of insurance put out a very strong statement saying, we're going to continue to cover hormone therapy, gender affirmation surgery. And Massachusetts didn't sign on to that. And we're kind of concerned at why that is. So we're trying to engage DOI and have them put out some kind of a statement that they will continue to require private insurance plans to cover transgender healthcare needs in the Commonwealth of Massachusetts. And I wanted to mention one other resource, and maybe I can send this to you, Noah, and you can put it in a link. But we, on the Fenway Institute website, and also on the Mass Transgender Political Coalition website, we put out 4 issue briefs about transgender healthcare during the COVID-19 pandemic. And they're aimed at individual transgender people, patients, but also at providers and insurers. And it's sort of how to deal with things like, right now, especially in states that are really hard hit, not so much here in Massachusetts anymore, but at the peak of the pandemic back in April, for example, only essential surgeries were happening. And gender affirmation surgery was considered non-essential at that time. And so it was hard to sort of talk to your provider, talk to your insurance company. We were encouraging providers not to use that language because we didn't think that was affirming of the patient. But also some very practical suggestions like trying to get prior authorization extended so that it's not only for 90 days, but it's for longer, maybe 180 days or a year, so that people don't have to go back and get prior authorization again, which is a very onerous process, so that they could, get whatever treatment they're seeking. So that just might be a useful resource for people. And I'll send a link to you, Noah, and Steph right now.
John, yeah, definitely send those to me. We've got about 5 minutes left, but Sean, that actually ties in perfectly with the question that we just received, which is, are there tips or trainings for providers trying to advocate for patients who might be dealing with insurance or hospital systems? And I don't know if you want to expand on that at all, or Chris, if you want to.
Are there tips for providers who are providing care to a transgender patient in terms of engaging with insurance companies or engaging with hospital systems?
Mm-hmm. Yeah, and I mean, you talked about the prior authorizations, and I'm wondering if you have any other thoughts to expand on that.
I know that we have a project at the Fenway Institute called the National, it's actually just changed its name today. It's called the National LGBTQIA+ Health Education Center. And their website used to be lgbthealtheducation.org. Hopefully that's still functioning and it'll send you to the newly named site. But that has a ton of resources for providers related to transgender health. So I would start there. I would also look at the WPATH website, the World Professional Association for Transgender Health. They have a lot of good resources for providers. So I would go to those two places, but people are also welcome to email me, and I can try to connect you to people who might have the information you're looking for. My email is skahill@fenwayhealth.org.
And I would just add that if you're a provider who believes that an insurance company or an insurance plan is improperly or discriminatorily limiting what it's covering, definitely contact GLAD Answers, our hotline, glad.org, because that's, there's ways to deal with that and we can help, but every situation is so different that I can't just give some kind of broad set of tips.
And the link for the LGBTQIA Health Center still works. And so, yeah, can still get to the website that way. And you can also email us, transhealth@fenwayhealth.org, and we'll also try to point you in the right direction. Chris, before we wrap up, I really want to hear about the federal case that you're working on. And this actually also ties in with the question that we just received, which is, are there any resources that you specifically recommend to keep up with the changing laws and Supreme Court decisions, especially for folks who don't have a law background but want to keep learning and getting involved with these issues? Okay,
so yes, we are putting out resources regularly on our website, glad.org website. And I know Fenway Health is also. So I think that paying attention to and being on the mailing lists for these organizations is honestly like a really great way to get updates. Also, just really quickly, I just want to underscore one point I don't think we've mentioned here, and I know we all think it's an important thing to mention, which is that all the health disparities and employment disparities and housing insecurity and other kinds of adversities that kind of disproportionately impact the LGBTQ community, those are especially pronounced when we're talking about intersectional identities. And so I just want to call that out, that Black people and other people of color experience this far worse than the other members of the LGBTQ community. And so the protections that we're talking about in terms of discrimination are so important, because the most marginalized among us are often the people who experience the worst forms of discrimination. So I just want to make this point about how intersectionality should be kind of first and foremost about how we think about and talk about these things. So that's what I wanted to.
Could I just echo that? That's such an important point, Chris. We did a study with LGBT youth of color in Boston about 5 years ago and asked them about experiences of discrimination. And the number one form of discrimination they experienced was racial, ethnic discrimination, then sex discrimination, and then thirdly, sexual orientation, fourthly, gender identity. And Tim and I have been recently doing a lit review on barriers to access to care. And I remember there was this one article we found, and it was about Black lesbians, and Black lesbians experience racial discrimination in healthcare. That's the most common form of discrimination that they experience. Then discrimination as women. So they experience discrimination as Black people, as women, and then thirdly, as lesbians. So, but the most common form of discrimination is racial, and then as women, sex discrimination. So that's really important. So we have these laws, but that doesn't mean that people are not experiencing racial discrimination in healthcare and in other parts of life. So.
And so if we still have a couple of minutes, I would love to talk about the lawsuit I'm litigating right now. So I represent a transgender man from Massachusetts. He's a hospice nurse, and he, so here in Massachusetts, and so there are discrimination laws that protect him, but his employer's self-funded health benefits plan has an exclusion that excludes, so it doesn't cover transition-related care. So any transition-related care isn't covered under this healthcare plan. And you know, he's someone who transitioned 20 years ago, and there's just a particular surgery that he needs right now because of where his gender dysphoria is at, and his employer is saying, no, we're not covering it, and we're not covering transition-related healthcare. Our plan excludes it, and we are standing by that. And so this Bostock decision, well, so we're suing on a couple of counts. One basis is Title VII sex discrimination, so the federal law. So Bostock, the decision from the Supreme Court, is definitely going to be really helpful in that. We were going to win anyway, but we're definitely going to win because of Bostock on that front. But then we also have a Affordable Care Act 1557 claim. So in essence, we're challenging the exact position that the Trump administration took when it released its final rule a couple of weeks ago. So we're going to get hopefully a very good, and hopefully very soon, we're going to get a good federal court ruling that says that interpretation of 1557 that makes you think that you can exclude transition-related care, that's unlawful, that's wrong. And if we get a judge to say that here in Massachusetts, a federal judge to say that in Massachusetts, that's going to set some great precedent for invalidating the rule down the line. So that's the lawsuit we're working on here at GLAAD. It's still in its early stages, and you know, it was filed back in January, but sometimes cases just move so slowly through federal courts, and so we're working on it. But stay tuned, and that case is, if you want to look up more information about it, is called Pangborn versus Ascend Health. Pangborn, Pangborn, and that's a lawsuit that GLAAD's litigating on behalf of Alexander Pangborn.
So much for sharing that. I'm looking forward to hearing about the win. We are out of time. I want to thank you, Chris, Sean, and Tim. I want to thank you all so much for joining. This has been really helpful. And yeah, so our next Q&A will be on Wednesday, August 5th from 12 to 1. The topic is still TBD, but we'll post it as soon as we know. And then if folks can submit questions either by email ahead of time or bring your questions to the event. And then one last event, which is coming up on Saturday, July 11th. It's called Working From Home, Celebrating Greater Boston's Trans Artists. And it's an online event to relax, feel connected, and enjoy local art and performances from some amazing trans artists. And you can RSVP at a link that I'm going to post in the chat right now through Eventbrite, and then the Zoom link will be sent out the day of the event. So yeah, with that, thank you all again for joining. This was a great conversation.
Okay.
Thank you.
Take care.